Any mention?
Yeah, please, Your Lordship.
Yes.
Your Lordship, I beg to mention item number 29. It's a joint request from the respondent number 7.
Item 29.
Yes,
Yes.
and for the respondent number 7.
1 to 6 are state respondents.
Yes. You are the petitioner.
Yes, Your Lordship.
Yes. What is your prayer?
The conducting counsel is not well, Your Lordship. And it's 2 weeks.
You can have it after 2 weeks, Lordship.
Does someone request me advice? So and so on behalf of respondent number so and so. Not opposed.
7?
No.
That will be 7.
7.
Respondent 7. Yes.
Up to 6.
1 to 6 is statement.
What is the matter about?
Pay parity now.
So who is respondent number 7 then?
Is the
It's
Joint Municipal Board.
Okay. So they are the main respondent.
Yes.
Okay. They are made in behalf of so and so. Not objected to by the London Council of Famous so and so. This is matter after 2 weeks. Yes.
Obliged, Your Lordship.
Wait, please, Your Lordship.
Yes.
Your Lordship, I beg to mention item number 32, Your Lordship.
Yes.
Your Lordship, as the conducting counsel is indisposed, Your Lordship, so I pray that the matter may come up after
You are
2 weeks,
appearing
Your
on
Lordship.
behalf.
I'm for the respondent, Your Lordship. No objection, Lordship.
Yes. Someone request me on behalf of so and so. This is matter after
2 weeks, Your Lordship.
2 weeks. Yes.
All right.
Supplementary cause list, item number 1.
Yes.
Well, at item number 1, these are all similar matters with item number 3, 5, 6.
Yes. Is this a way? Please go outside, put on your gown and come back. Yes.
Well, see, these are those matters with where these services has been terminated and those services has been reverted back.
Who appears for the petition? It's not there.
Mr. Walang is appearing for the petition.
There is no one.
He was just here.
Yes.
But
Is it
Your
your
Lordship,
matter?
have to. Sorry for causing inconvenience from this honorable court, Your Lordship.
There is no inconvenience.
So sorry,
there is a
I've
manner.
we have just
There
come
is a manner.
from.
You being a senior lawyer, you must know.
Misunderstood.
You cannot come inside courtroom and put on your gown.
Misunderstood. Misunderstood. I bow down before this honorable court.
Is this your matter?
Yes, Your Lordship.
So appear then.
Yes, Your Lordship.
These
On
are
behalf
all-
of the petitioner, Your Lordship,
Yes.
filing the writ petition, being aggrieved of the Annexure 4 in the petition, Your Lordship.
So these are all same matter.
Yes, the same, Your Lordship.
Yes.
It's being reverted back to the.
So how long will take
To the
to file
casual.
your response
Well,
here?
I'm praying for 2 weeks' time for all these matters.
So this will be same orders.
Same orders.
in this
Yes, Your Lordship.
matter.
I've also,
The petition issue.
I've also filed my business application, Your
Yes,
Lordship.
yes. We'll pass an interim order
Yes.
because in all other matters, similar
Yes.
matters, we passed an interim order.
Yes.
So I'll get the benefit of the same thing.
Yes.
With similar order, and we'll have it after 2 weeks. Okay, just say so and so. You should not issue after 2 weeks. It's just like before the order, but then make it 2 weeks. Yes.
Highly obliged, Your Lordship.
And the interim order will be like before the other case. You can take care. Just see the petition.
Yes. Highly obliged.
Lordships, item number 1, 3, then 5 to 12.
Just a minute. Let us come. Let us just
Yeah,
come. So just let us.
Item number 2.
Please, Lordship.
Yes.
Lordship, petitioner husband was employed as a lower division assistant at United Songsak Division Secondary School, Lordship. Lordship, appointment letter is at Annexure 2, Lordship. Kindly have page number 10, Lordship. And
What is the controversy here?
Lordship, after rendering unblemished service, the petitioner husband was retired on the age of superannuation in September 2017, Lordship. And after retirement, petitioner husband has approached the competent authority to release the gratuity. But However, unfortunately, petitioner
He
had.
was an employee of the deficit school.
Yes, Lordship.
And what is the benefit he is entitled to after retirement?
Gratuity, Lordship.
Gratuity.
Yes, Lordship.
Yes, Mr. Khan.
Accepting
What,
notice of the
what are the benefits which this employee of a deficit school is entitled to?
because he's claiming for all these.
DC or GDC?
Yes, for sure. So I'll have to take instructions from the department.
It's okay. Hard.
For respondent 1, 2, 3.
You are Mr. M.R. Marak.
Yes, Lordship, M.R.
sir,
Marak.
Mr. M.R. Marak. Learned counsel for the petition. Issue notice returnable in 3 weeks.
3 weeks.
Learned GA. APS for the. APS for
Respondent 1, 2, 3.
1, 2, and 3. Stop. The petitioner shall take steps for service of notice of the respondent number 4. This after 3 weeks. You take steps for take steps within 2 days. Huh? Yes.
Much obliged.
Item number 3.
Yes, Mr. Sangma.
This is the same matter only, my lord.
Yes.
In this case, my lord, the
Oh, this is a new case again.
new case, my lord.
Yes.
Only thing is that, my lord, in this matter, the petitioner was appointed as a chain man. After that, after appointment with regular pay scale,
It was
discontinued.
a direct appointment.
Direct
It was
appointment.
not from casual to.
No, my lord, direct appointment with regular pay scale.
But then appointment was regular.
My lord.
Take decision.
weeks, my lord.
There are many aspects. There are many queries which may come up. So
Lordships.
be ready with.
My lord.
This court will ask you. Because you see, appointment at will and termination at will, probably something you have to
I
deal with.
understand, your lordship.
This also will be same order. There is an interim order also.
We have prayed for entry mode also, my lord.
Yes.
This case is
There is
demolished.
not a regulation, direct recruitment and termination.
My lord.
So this also will be same order, and then it will come up on the same thing after 2 weeks.
After 2 weeks, all these matters.
Which are other matters?
My lord, here the main list of item number 1 to 25.
Okay, that just let
Let
the
it be
matter
called, my
called.
lord.
Let it be called.
Ma'am.
Just wait first. Yes, call the next one.
Item number 4.
Yes, Dr. Mojika, what is this?
Well, this is an appeal against acquittal, my lord, prosecuted by CBI. The matter came up on last occasion. So
Oh,
now I have filed in a separate application for leave, my lord. That is. Registered as this case number 54.
We'll issue notice.
Well, the six accused response,
Appeal against acquittal.
my lord.
Okay. Dr. and Mojika, London Council. This will be in the miss case. Huh? London Council for the London DSGA appearing for the so and so assisted by so and so. Okay, London Council for the applicant. Issue not. Give a stop. Just say before you say hard, you just say this is an application under section 419 subclause 3. This is if these are convictions are under this original case is under IPC and all. Why it is appeal is under new provision? I do not know. This part has still remained something is not very clear. Though may not be very vital for the thing, but then we do not know. Anyway, this is an application. Just say this is an application seeking leave to appeal against judgment and order of acquittal dated 4/3/2025 passed by the London Special Judge within bracket CBI Shillong in special within bracket CBI case number 13 of 2023. Then it's next, just you say hard Dr. Mojika, Learned DSGA, assisted by so and so. Issue notice, returnable in 3 weeks. The applicant shall take steps for service of notice upon the respondent within 2 days. List after 3 weeks. Yes. Deputy.
Item number 5.
Yes.
You're
Yeah,
going to
you
play
can-
for, my lord, I'm
Yes.
playing for time to file my affidavit.
Anything order? Anything more?
Yes.
5 to 12, my lord.
Yeah. This is paid for by Mr. Salma, London Council paying for the respondents. 2 weeks time is granted for filing counter affidavit in the matter.
Well, interim order is there till the returnable date, my lord. That may be extended, my lord.
Just the interim order in the miss case, isn't it?
My lord.
Just miss case, just say list along with the main case. Then say the say interim order passed earlier shall continue till the return of verdict. Yes.
5 to
How many matters are there?
5 to 12, my lord.
5 to 12, my lord.
Same orders.
Same orders, my lord.
5 to 12 same orders. Okay. And this list those matters including these motions. Yes.
The list. Item number 1.
You also similar play, my lord.
There are some matters also daily.
Yeah, lord.
This how many items are there in the daily?
1 to 25, my lord.
Same orders.
Same orders, my
Same
lord.
orders.
Miss case also, my lord.
Main case and this. Now this is basically she is taking care of everything. You see that is very confusing. And then probably if you prepare a chart before the final hearing and all,
No, lord, we'll do that.
to the post concern and
My lord, we'll do
post
that.
regulation that will help the court. Otherwise
We'll do
it's
that.
difficult.
My lord,
Since
we'll
we
do
cannot pass common order,
Your lord.
with different things. So
Different
that is what
post.
the problem is.
My lord. We'll prepare a chart, my lord.
This will be
2 weeks, my lord. Allah.
same
Obliged.
26.
interim also same. All those. Yes.
Lordship, I'm still awaiting instructions.
Yes. What happened? There is no
Mr.
clearance
Jha.
nowadays for the petitioner. None appears for the petitioner.
Give me 2 weeks, my lord.
Is spread for by MSS and London GA. Further 2 weeks is granted
Grateful.
for obtaining necessary instruction.
Yes, Your Honor.
This is a what, pensionary benefit or what?
Yes, they are trying to revoke compassionate
Oh,
appointments.
compassionate appointment.
Grateful, Your Honor.
Hearing, item number 30.
Please, my lords. This is a matter under section 482 of the CRPC, my lords, the old code. What had essentially happened in this matter is, my lords, there was an incident that happened on the 28th of August 2022. A scuffle, my lords, between two brothers. I am the elder one, my lords. I and my family members had sustained injuries in that scuffle, my lords. Those medical records are on record. We had filed an FIR. Now, pursuant to my FIR, my lords, a counter FIR was also filed by my younger brother on the same day. Against that proceedings, my lords, we are here before your lordships.
Is the case registered under what section?
Well, it's against me, it's registered under 323, 506, and 34. Hurt.
323, 506.
My lords.
These are otherwise compoundable, isn't it?
Otherwise, my lords.
324, my lord, not 23.
23 is. No.
324 is not compoundable. Compoundable.
This is this amount. 324, 506.
Actually, they've changed.
506 is not.
506 is
in
not.
Meghalaya, your lordship, it's non-compoundable. It's not and non-billable.
So there is no likelihood of compromise between the parties here.
My lord, I have made an attempt. I have already expressed my desire, but
Elder
they did
brother
not
is
come forward.
elder brother is not willing.
Yes.
Yes. Yes, yes.
I'll take your lordships.
This is a fight between two brothers.
Two brothers, my lords, one fateful day.
And then it's just a couple also you do not want to compromise.
My lords, the difficulty is the ladies of the house.
See.
My lords, the difficulty is the ladies of the house got involved.
Anyway, it's whatever. It's up to your desire. Yes.
Lords, if I may take your lordships, my lords.
You are seeking quashing of the FIR.
My lords. Because it's a pure counterblast, my lords.
Matter has been charge sheeted.
Both these two cases have been charge sheeted.
So charge sheet is also under challenge here.
My lords.
That has been brought into the.
We've subsequently brought it on.
Yes, yes.
Well, I'll first take my lords to my FIR. My lords would find it at page 20. Minutes. My lords, may I?
Yes, yes, please.
This is the typed copy. It says, respected sir, this is to inform you that my brother Sheikh Mohammed Ashik and his son Mohammed Ariman and Ruxana Parveen came to our residence on 28/8/2022 at about 2:30 p.m. or in or about 2:30 to 3 p.m. with the intention and attempt to murder my wife. All this happened after 10 minutes. I had an argument with my, it should be my brother, Millets, Sheikh Mohammed Ashik, on the same property which is already settled by my father. He and his family came with a cricket bat, rang our doorbell. My wife was seriously injured by Ruxana Parveen. In an attempt to save her, I and my son were also hurt by Ashik and his son with a cricket bat. All this happens because Ashik has already threatened to teach me a lesson several times, and on this day also he threatened to do so, and he did. Now,
This FIR was lodged on 28/8/2000.
28/8/2022, my lords.
On the same day.
Based on this, my lords, Shillong Sadar PS case number 2028 of 2022 was registered. Now, Annexure 3 series, millets, is the medical injuries that have been sustained by us, me, my wife, and my son, millets. As a matter of fact, my minor son was seriously injured in this entire incident. If I may just quickly take your lordships to page 29A. He had to be admitted in hospital for a couple of days, millets, and my wife sustained injuries on her head.
What bearing those will have on the FIR filed by them?
Well, it's no. To show Malaj that what had actually happened and how the counter FIR then comes into play. It says, admittedly, Malaj, it was filed at the subsequent point of time.
To what extent we can go and, you see, like go into the facts?
No, I am only taking this for your lordships, Malaj. An incident happens, Malaj. When an incident happens, one party sustains injuries. Now, the very party who sustained the injuries, Malaj, against them an FIR is filed. And Malaj, a botched up investigation is made on the basis of which a charge sheet is filed against the very people who got injured in this incident. If your lordships will see that if somebody is injured on the head, Malaj, requiring stitches and admission in hospital, how would that person, Malaj, be in a position to actually injure the other side? And no medical records are there insofar as the other side is concerned. That it is only relevant to that limited extent.
Yes.
So,
this page 29,
Malaj.
These are photographs taken by whom?
Well, these were photographs taken by us after admission in the hospitals.
Is it admissible in law?
Well, the medical records will bear me out. This is only for the purposes of a depiction of what actually came out of this incident. The medical records, these are when we were taken for medical by the police authorities, and the report of the civil hospital, would find at page 23. You have typed copies of this?
Yes, page 23A is a typed copy.
Typed copy, Mills.
Yes.
Your lordships will kindly see PAB informed injury on scalp.
Yes.
Then alleged assault, vomiting, LOC, seizures, Mills. So this is that injury on scalp, Mills, for the page 29A, Mills. I was just pointing out this is the injury on the scalp.
This is 324, isn't it? The offence is under 324.
323.
323.
324, sorry.
323 may not. You were admitted in hospital.
Lordships.
For how long you remained there?
2 days, Mills. That is what I'm saying.
324 deals with grievous hurt.
Grievous hurt, Mills.
For what is the requirement of law? That how many days a patient need to be treated as indoor?
7 days, Mills. 7 days.
So you were lesser than 7 days?
Lesser than 7 days.
Now, anywhere it is shown that you have been treated as indoor patient?
Mills, the medical records of Bethany Hospital, Mills, the discharge summary is there.
But then see, this so far as civil hospital certificate is concerned, which you have referred just now,
Mills.
there is nothing that you have been admitted.
No, Mills, that's
for
not there.
observation or anything.
Lordships. The medical certificate is at page 26, Mills. That's a discharge summary from Bethany Hospital. He was, Mills.
What is this, page 24?
24, Mills, is the medical certificate of Fahim, Mills. He is the child who was admitted in Bethany subsequently.
Yes.
He was admitted on the 26th, Mills, and discharged. He was admitted on the 30th and discharged on the 2nd of September 2020.
Then this 23 was whose? Ruxana, yes.
Ruxana, that's the mother, Mills. Fahim is the son, Mills, who is 16 years old.
Okay.
Mills may kindly see its date of admission, Mills, is on 30th of August 2022.
Referring to page?
Page 26, Mills.
This is your son's?
Sons. Page 24, what my lord was referring to, Mills. 30th of August 2022 is admitted and he is discharged on the 2nd of September 2022. And Mills, the discharge summary.
Okay.
Mills, may I just read? Admitting history. Patient presented to the ER with complaints of severe headache, body ache, and chest pain for prior to 2 days of admission. Patient also complained of pain all over the face, vomiting 2 episodes. Denied history of loss of consciousness in seizure, ENT bleed followed the assault. alleged history of assault by his relative at his own residence on 28/8/2022 at about 3 p.m. Patient was hit by a wooden bat multiple times on the head and neck. If my lords have it.
You know, this is a recording by medical officer, isn't it?
Lordship.
Now he records it on basis of whose information?
Our information. Well, that's okay. I'm just taking your lordships through the entire.
So probably if you tell this court to believe it,
Well,
just because it is reflected here.
no, that is my. Well, it's the history prior to admission. I'm conscious of that. Well, that's prior to admission. My lords, then next page, my lords will kindly see at page 27. That is the evaluation by the doctor, my lords.
Yes. All right. These are, let us. But then these are part of documents which the police investigation revealed, or this is all your document.
I'm sorry, my lords.
These are all your document.
Lordships.
So these are all your. Say supposing at this stage.
Lordships.
To what extent we take into consideration the documents brought in by the person who is seeking quashing of the FIR? What the law says? Can you?
Your lordships are absolutely correct. I would have to work myself out within the parameters of Bhajan Lal, my lords, not beyond that. Reason, my lords, for
Perhaps there are a decision if subject to
my lords.
correction by you. Probably there is a decision that where it says that the document
At this stage.
at this should not be looked into.
Your lordships will look at
the
the substance of the complaint, my lords, only at that stage, which is why I submitted, my lords, that I would have to confine myself within the parameters of Bhajan Lal.
No, but then if you are trying to prove the
Balance.
nature of injury sustained by you
Balance.
on the basis of documents annexed by you, then it would become very difficult.
Lordships, I am not on that. As I pointed out, my lords, that I had initially submitted before lordship.
No, but then your submission was something like that a person who has received injury, you see, now he is
now being tried, my lords.
So that is okay, but then the nature of injury, if you want to, you see, like if you want that this court should take the cognizance of the injury.
No, I am not. I am not on that, my lords. That there's a charge sheet file trial will follow. My case has been charge sheeted, so there is no grievance insofar as that aspect is concerned. I am only pointing this out, my lords, for the extent that if my son and my wife, my lords, are both seriously injured in this incident, which is borne out by medical evidence, my lords, in that context, now I'll take your lordships to the FIR. I'm just placing the history, my lords, what actually transpired in this incident.
See, these are all matters of evidence. You see, that is something what is a problem for this court, because this court probably has, you see, certain limits of its jurisdiction. It cannot.
At the stage of 482, my lords, I bow down.
So that is what.
My lords, I bow down. Which is why, my lords, I will have to come within the four corners of the law laid down, my lords, that in these circumstances, because this will not be one of those cases, my lords, where the allegations itself are so absurd that your lordships will then invoke 482. So, my lords, then I will have to corroborate and build up a case saying that, my lords, to come within that purview, I would have to show that somebody who is injured, my lords, who requires admission in hospital, who is requiring stitches, who is requiring, my lords, medical intervention, whether in these circumstances, the allegations in the FIR could be, my lords, a reasonable person could have come to a conclusion that this my lords, action could have been taken by this injured person to this unlimited extent. That is what I'm trying to point out. If my lords now have the FIR at page 21, my lords, and exit 2. Now this is the FIR against me.
It appears to be longer than your FIR.
Well thought out, my lords. The difficulty, my lords, if I may, and this is something that my lords would have been aware. What now is the trend is, my lords, if an incident happens, I file an FIR informing the police of a certain incident that has happened. The best possible course of action, which is usually adopted by, my lords, the perpetrators, is a counter FIR is immediately filed. The unfortunate part and the truth is, my lords, the police, instead of investigating and coming to a proper conclusion as to what actually happened, decides to take a very safe route and charge sheets both the FIRs, saying let the courts decide it. And I'll take your lordships to the charge sheet. Now, this is also dated the 28th of August 2022.
Yes. What happened to the other case, the case filed by you?
Charge sheeted.
I am facing the trial, my lord. It was fixed yesterday, day before yesterday.
Okay, that is trial is going on.
Yes, my lord. It's fixed for evidence.
That's what I submitted, my lords. What the police decide is, unfortunately, why people have to come before my lords under 482 is, there's an incident, my lords. Either way, not on this case, my lords. In various matters, what we've seen is, there's an incident, my lords. I file an FIR, a counter FIR is filed. Police does a botched up investigation, my lords, without actually saying that this is a true FIR, this is a false FIR. They decide to charge sheet both these two matters. And they leave it to the courts then to decide. And a person, my lords, who's a victim of an offence, then has to face a trial just to prove that, yes, I got assaulted on that day and I did not have anything to do.
Is it not that when both, say like two parties are involved in fighting,
My lords.
you see, both are equally offender?
There could be
It
a
may
case.
happen that, see, maybe you are weaker, so you receive more.
Lordship.
Okay.
But no, I'm not restraining myself to this particular case, my lords.
The problem is, see, like the thing is that what happens, see, like this kind of situation, if investigation reveals that both the parties are at fault, then what is wrong in?
No, it would be like this, my lords. If I may just draw on a larger context, my lords. If somebody assaults me, and in self-defense, my lords, this is natural. If somebody assaults me, my lords, there would be some reaction. Now, in that course of that reaction, my lords, if I file an FIR saying that that person assaulted me and I try to defend myself, naturally, it would but be natural, my lords, that I'll defend myself. And there are two counter FIRs. Police, my lords, then does not find out what is the source of that entire dispute.
It is difficult sometimes, you see, it may not be something like that this one party is responsible for attack. It may happen.
No.
Both intended to attack each other.
What I'm submitting cannot be exhaustive.
So
but I'm saying, my lords, that there can be instances like this.
These are few arenas, see, like probably this court will not go into all those things at this stage.
My lords.
Now, this is what the difficulty is. Now, the thing is that if your submission otherwise is confined to the FIR, the allegation made in the FIR and charge sheet, I think that would be a better way these things. But
I'm going on that only.
If you try to drag to the what actually happened according to you,
that may not be relevant for the purposes of
and then
482.
you'd like to court to go take into consideration those things and give a finding on that, then
No, my lords, I cannot. In 482, I cannot, my lords, make that request before this honorable court. The only reason why I pointed out my FIR, my lords, and the medical history is that for the purposes of establishing, my lords, that if somebody has sustained injuries, whether it is possible in those circumstances, my lords, for that person to be an offender to the extent that, my lords, a case is registered against him under 324.
no, the things come back to again same thing. If you want to say that whether it is possible for an injured person to do it, now then we have to first come and give a finding that you were actually injured.
My lords, my charge sheet says so. The case where I filed, my lords, that's charge sheeted. They say that I have been injured. Unfortunately, my lords, which is a lacuna in these proceedings.
That charge sheet is also a part of this.
My lords, I'm sorry, this is what I was trying to point out. We filed our charge sheet also.
It was only brought on record, my lord. They have not challenged the charge sheet.
No,
That's not
their
that-
charge sheet, why they should challenge? That is their charge sheet which has been filed,
My lord.
where you are facing a trial. Why should they?
In which you are facing a trial.
Oh, that charge sheet.
Well, that unfortunately is not a part of the record. That's what I'm.
And even assuming that
Well,
what you say,
well, it's-
it is correct, and that the fact that you have received injury, that is recorded in that charge sheet.
Well,
To
it's-
what extent this court can take cognizance of that charge sheet?
My lords,
Charge sheet doesn't come under the category of evidence.
it does not. My lords.
It cannot be treated as a record of evidence in another judicial proceeding.
It cannot be. My lords.
So this can that bind this court?
No, it would have some persuasive value on this court, my lords. Because the law is otherwise also well settled, my lords, that I cannot initiate any kind of criminal proceedings malified. That aspect, my lords, will kindly have to see. That if I know, my lords, I have committed a crime, and to, my lords, thwart any kind of prosecution against me, what I simply do is go and file another counter FIR against the person. Whether that would be permissible, my lords, that your lordships are aware can be examined by my lords under 480.
How you see, until and unless FIR exhibits mala fide, How will come to that fact?
My lords, that is what I'm saying. If my FIR, my lords, establishes that there is substance in my FIR, my lords, because if there was no substance in my FIR, my lords, the matter could have been closed on final report.
That is so far as
So the
UFI is
police
concerned.
says, my lords, that there is a prima facie case.
Right now, we are not much concerned about your FIR, except to the fact that you filed FIR.
And which has been
this
charged
counts as
sheeted.
counted.
And which has been charged.
But so far the contents is concerned, probably we are not much concerned at this stage.
My lords.
Now we are more, so far as the allegations are concerned, we are more concerned with the FIR.
FIR filed by them. That is the primary proceedings before your lordship.
Let us go
My
through that
lords.
and just see what is there.
My lords. I'll take your lordships to page 21, my lords.
Yes.
With reference to the subject cited above, I, Sheikh Mohammed Ashik, so-and-so, beg to report that at around 2:30 p.m. when I went to meet the workers who were doing some renovation, it should be, my lords, renovation.
Sorry, Mr. Paul.
My lords.
Which FIR was lodged at what time?
My lords,
What is the
the time of both the FIRs, my lords, mine was first in point of time, which is pointed out, my lords, because my case is registered as Sadar PS case number.
Yes.
Sadar PS case number 202.
Yes.
Theirs is registered as 203.
Now,
Well, the charge sheet would bear me out insofar as the time of filing of the FIR.
What is the difference of timing of lodging this FIR?
I'm sorry, my lords.
What is the difference of timing?
My lords, that is a pertinent question, my lords. I'll have to satisfy lordships of that. Insofar as their
You want to
FIR
say
is
that
concerned.
This has come as counter affidavit, so that can be a basis. You can say that
Insofar as their FIR is concerned, my lords, it's filed at 7:55 p.m.
in the evening. Okay.
My
So,
lords.
yes, 7:58 p.m. And then you.
Where is our FIR? Where is the charge sheet that will bear the time? I'm sorry, my lords. I'm a little handicapped in this because our charge sheet is not here before your lordships.
No, but then it is your case that is a counter FIR.
Yes, my lords. Because, my lords, why I'll point it out, that would be correct, is the medical report. When I was produced before civil hospital, my lords, that time would be mentioned.
You see, even they can take you for medical
Later.
checkup before or after. So after report, we are getting.
I would have, my lords,
Yes, we'd like to know
the
that
charge sheet would reflect that, my lords.
Since there is an argument raised by you that this is a count, it casts as a counter.
That would be the foundation of this
that,
entire thing.
We would like to see what is the
Time difference,
time difference.
my lords.
Just to, you see, satisfy ourselves that the respondent had the time. You see, it was a well thought plan to do it.
My lords. Would my lords then just kindly grant me a day's accommodation, my lords? What we'll do is, my lords, we'll also have a
You
copy
have any
of
information with regard to that? Oh, we are not these things. But then about the
Actually,
timing
I did
and all.
not bring that file, my lord. I have that file with me. But there is not much difference, my
We do
lord.
not
It was
understand
just
why-
within a span
why-
of 2-3 hours. The second FIR has
3
been
hours
filed.
is a lot of time.
I do not understand why you two brothers are fighting.
My
We
lord,
are
that's
still
the problem here. The problem is, my lord.
Do you reside in the same place?
Same building, your lord.
Same building, my lords.
Even till now, you reside in the same
Till
place.
now. My lord, it is actually a dispute of a flat. In the second floor, this property has been settled among the 3 brothers. The father has settled. It belonged to the father. There are 3 flats in that building, my lord. One is occupied by me, one is occupied by them, and one is occupied by our younger brother. Now, younger brother does not reside in Shillong. He resides in Calcutta. So, he has given the custody of this flat to me. That in my absence, you can utilize it as well as take care of it. And that is what exactly I was doing, my lord, in his absence. I was taking care of that flat and I saw some repair works was required. So I called for the laborers. And they inspected and they started the repair work. This is where the problem started, my lord.
They wanted control of this.
They wanted control of this and they interfered into it. In fact, they have chased the laborers. Laborers are the eyewitness in my case, my lord. Their statement is recorded.
So where is it?
CCTV footage is also seized, my lord.
That is already. We are not going to all those things. This court will, you see, this will not add any weightage to your case.
He is
here.
talking about the
Where
incident.
is where is your third brother now? And
He has come now. He's staying now. And he's staying with me. And with entire family.
it's all right, no problem. That is okay. but then the thing is that then anyway, it's up to you. We do not know.
My lord,
This
here,
appears to be 324 case and all, so not very major also.
my lord, there is both sides. They are no less. The source my friend was talking, that the police did not investigate the source. Here is the source. They are the one who instigated this.
So, my lord's
They
instigation
are
would
the
lead
person-
to
now here,
assault.
my lord, the question is that they are saying one thing and I'm saying another. Now this becomes a disputed fact. Whether this honourable court will go into
Definitely,
that
we
disputed
know.
facts? No. In fact, under 482, facts are not required to be gone into. The judgment is here, my lord. I will place it as and when required.
Yeah, that is okay. These are well settled position. I don't.
My lord.
See, this will be.
Question is, my lord, his FIR should be quashed and my FIR should continue. I should face the music, and he should go scot free. The person who initiated this.
If you do it, if your FIR comes as a revenge.
No,
Okay,
it is
so-
not a revenge, my lord. That's what I'm telling.
Definitely. So that is. Let us see.
My
Well,
lord.
as a matter of fact, this FIR at page 21 is very interesting. If my lords, I just read out the FIR. May I just read?
Yes, please.
With reference to the subject set above, I, Sheikh Mohammad Ashik, resident of so-and-so Meghalaya, beg to report to you that around 2:30 p.m. when I went to meet the workers who were doing some renovation works in my flat situated on the
Is it
second...
reservation work or renovation?
Well, it'd be renovation, Mills. There's a typographical error. Of Didar Market, adjacent to Sheikh Mohammad Aman's flat, my brother Sheikh Mohammad Aman, along with his wife, entered my flat and passed some instigating comments, to which I countered them, but my brother did not answer one properly, but instead assaulted me and left after around 20 minutes. He and his son came back and started commenting various instigating work, and the said flat, which was in renovation, does not belong to me. Therefore, all work should be stopped immediately. He asked all the workers to stop work and to get out of the flat immediately. I pleaded with him not to do such act with the workers and let the work continue, and I also requested him to leave my flat immediately, to which he began quarrelling with me and started pushing me several times. I also pushed him and he fell down. He got up and with his son, both of them assaulted me on my head and shoulders. The workers have all witnessed the incident. My brother also threatened to kill me. I did not assault them back and left. I called my wife and son and they came to talk with my brother and his wife as to why they stopped the work and assaulted me. Various heated words were exchanged, and in the ensuing quarrel, my brother's wife threw her slipper at my wife and my wife countered her and pushed her, which she got hurt by hitting her head on the window pane and glass. Now, this statement is very important, my lords. I would request your lordships to kindly take note of this. And my wife in counter her and pushed her, which she got hurt by hitting her head on the window pane and glass and got hurt. But to my utter shock, I saw his son come with an air gun. I asked my brother that, do you want to kill us? Which he answered in affirmative. In the ensuing quarrel, my son also got involved, but his wife got hurt by hitting her head on the glass on the window. As she started to bleed, my wife begged her to stop the quarrel and get herself checked, to which the stop the quarrel, I'm sure there's a major goof up in the translation. Quarrel by said they would file FIR against us. The whole family is in dispute and I have also been assaulted, and whatever had happened to my brother or his wife is purely for our self-defense, and we are not carrying any sharp weapon. They have also threatened to kill my son as he got involved in the quarrel. Three aspects become very clear, Millins, that it is more a very defensive FIR. Now, the charge sheet, Millins, which has been...
You can call it very fair FIR also.
I'm sorry, Millins.
You can call it very fair FIR also.
I would say, Millins, it's fair. But then it also establishes, my lords, two things. A, there was an injury. There is an answer to that injury, my lords, which has been created at this stage. Your lordships will kindly indicate, my lords, appreciate that A, there is an injury, my lords, which is admitted. There is a story which is planted at this stage, my lords, that it is because of a window and a window pane. Second part of it, my lords, is there is an incident of assault, and he says that I have also been assaulted. The last paragraph, I also has been assaulted, and whatever has happened to my brother or his wife is purely for our self-defense. So, the plea of self-defense is being raised even at this stage. This is even at the stage of filing of the FIR. Well, we have brought the charge sheet on record by way of an additional affidavit that was filed. and that was filed on the 1st of August 2023. My lords, page 16 onwards, my lords. Page 16, my lords, is the narration of the incident.
Yes.
And down below, my lords, during the course of investigation, the following steps were taken in as follows. Person sent for medical examination. That would be very pertinent, my lords. On 28/8/2022, the complainant Sheikh Mohammad Ashik and his wife Rukhsana Parveen and the son Sheikh Mohammad Sonso of Police Bazaar was sent for their medical examination at Civil Hospital Shillong, where the attending medical officer Dr. I. Wajuri opined simple injury in nature for Sheikh Mohammad Ashik and Rukhsana Parveen, and for Sonso opined no external injury. Dear my lords, these are the statements recorded. It's page 17, my lords. This is a statement of the complainant. He says, my lords, examined him where he stated that my name and address is so-and-so. Further, I'd like to state that on the 28th of August 2022, at about 2:30 to 3 p.m., went to my flat situated on the second floor of Didar Market to look after some renovation work, which I allotted to some workers, and after a few minutes, my younger brother, Sheikh Mohammad Ahmad, along with his wife Rukhsana Yasmin, entered my flat, and on seeing the renovation work, my brother started using abusive languages and provoking words, and said that
Your younger brother means like that is?
I am the younger brother, Milids.
Oh, so he is the
I
elder
think
brother.
Ashik, Aman, and then there is the one more youngest.
Yes.
Started abusive languages and provoking words and said that the work should be stopped, that the flat does not belong to me. With these words, they left. Now, my lords, may I kindly have a note of this?
You are just like a trial court. You are telling us to appreciate.
No, I'm not, Milids. I'm not. What I'm simply saying is how the narrative changes. I'm only pointing out at the change of the narrative, Milids, because I'll have to place the law for your lordships to appreciate that.
These are 161 statement.
161
not even, you see, admissible in law until
It is not.
unless a witness is confronted with this.
Lordships.
In terms of section 162 CRPC, isn't
Lordships.
it?
Lordships.
So at this age, only for the purpose of, you see, like
482.
Yes, the prima facie satisfaction. Whether there is any, you see, like a disclosure of commission of any offence or not. That is what we have to see. Nothing more than
Which
that.
is what I'm saying, my lords. Because your lordships would see, having seen in the FIR, he says, my lords, even at this stage, he was assaulted. What he's saying now is that I've not been assaulted at that stage. In the FIR, my lords, he says that initially he comes in, verbal abuse, assault. Goes back, comes back with the wife and son, my lords, again assault. Wife gets injured. We ask them to stop the quarrel. And my lords, they say they'll file FIR. And then they come and we go and file an FIR. That's the case, my lords, if I can presuppose it. And this is what happens. My lords, as your lordships have rightly pointed out, these are under 161, so they will otherwise have not too much of a bearing insofar as these proceedings are concerned, but only for the purposes of how the narrative is changing. I replied them to read the family settlement. My lords, it's I replied to them to read the family settlement agreement properly as to whom the flat belongs. On this, he began to quarrel with me. He threw out the workers and warned them of dire consequences if they didn't stop the work immediately. He even pushed one or two of the workers out of the flat. I requested him not to do so and let the work continue as the flat does not belong to him and leave the flat immediately, to which he became adamant and began to push me and asked me to leave the flat. I asked him not to push me around, but he didn't stop. I gave him a push and he fell down, and on getting up, he and his son assaulted me.
Narrations in the FIR.
Balance.
Yes.
Then he says, my lords, during this heated exchange, my lords, next paragraph is very important. They also kick and threatened me with my life as I defended to his beating, and also son getting involved and beating me. After this, they left, and I informed my wife of mutual talk with them about the incident. His sons came out with an air gun in his hand, heated exchange of words between us. During this heated exchange, my brother's wife threw her slipper to hit my wife, to which my wife got angry and quarrel turned ugly. And in this quarrel, his wife somehow got hurt.
Same thing, ditto, same thing. It's already there in the thing.
No, well, it's there, it is window pane.
Same thing, got hurt anyway.
As my wife was defending herself from physical abuse, it was not intentional motive to hurt anybody, and after she got hurt, my wife herself pleaded to stop the quarrel and attend to her wound, to which was agreed, but they also filed a FIR against us. So then they say that it is on the basis of they say some CCTV footage and things, etc. And this is important, I'll just read. The whole incident happened here in a very short time, and neither or my wife carrying any sort of weapon to hurt anyone. Whatever happened has happened, was in the heat of the moment, and most probably my brother's wife had hit herself, it will be, by the window glass, which is broke when the quarrel was happening. Statements are 164 we recorded in the parties. Very short.
This FIR, their FIR came after how long of that timing of
My lords, we're just seeking instructions, my lords. We don't have that readily. I wanted to point that out to your lordships. Yes, your lordships have rightly, my lords, indicated the duration of the difference of time between their FIR and my FIR and their FIR would, my lords, then go on to establish the motives of this particular.
That is
one of the indicators only.
Mainly because of the reason that we cannot appreciate and represent the evidence.
Not at this stage.
We have to go by those facts.
Those facts.
So that is.
And also, my lords, I was just asking for instructions, my lords, whether statements under 164 have been recorded, because I am not aware of the trial court proceedings. That would be of more persuasive value before your lordship.
Well, my lord, the 1482 is very limited. He's arguing the whole case on merit.
Arguing the whole case on merit will only happen when the evidence comes.
You are arguing it. Whole case on merit of facts. Because your lordship under 482 facts will not be gone into. This is the judgment. My lord, I will place it before your lordship.
Mr. Mansoori, please wait.
My lord.
Where is the state? Yes, it is your role first to defend. If it comes to submission, Mr. Paul has not finished till now. Wait. Let him establish the case. You see, enough. The court is also putting, hurdles in his submission. Every now and then asking question. So he is not having a very smooth ride here.
My friend wants to add some more speed breakers on that.
Unnecessarily, he's leading to some place where we should not be going.
See, his basically task is to show that this FIR, your FIR comes as a counter first.
Counter FIR is also permissible.
Wait.
It's also permissible.
No, he's not saying that it's not permissible.
My lord. He's saying that the injuries I have sustained, I should not have filed the FIR. I have sustained more injuries than they have sustained.
That is how the court knows which way to take that.
My lord.
Those submissions. It's okay. Only thing is that if he is alleging some malafide,
right.
Okay, then in such a case, he must have the opportunity to establish it.
My lord,
that is what he is doing.
My lord, but these facts.
That is this. You see, without going to the facts, also how he will establish malafide.
My lord, he should go through my
FIR. To some extent, he will have to.
He is going through his FIR, his charge sheet. Everything
No,
is.
no, I'm not. That's your charge sheet.
No.
He has not gone through his charge sheet. No, he is reading your charge sheet.
My charge sheet is not part of the record. That's what I'm trying to say.
See,
My lord, my apologies. Let him continue.
yeah, definitely allow him to continue. Yes. Now, Mr. Paul, the points which you are urging shortly is that the FIR comes as a counterblast.
Knowledge.
This is one aspect. Second thing is that the allegation made in the FIR basically doesn't make out any case against.
My lords, I say it establishes a case against the complainants in this case because, my lords, two facts are borne out by that. A, my lords, that there was some serious injury to my wife. A story is then sought to be created, my lords, that it is because of a window pane.
Yes, please.
Because what I'm trying to submit before your lordships is, my lords, the FIR itself is initiated malified. This an FIR would essentially be a narration of whatever happened, my lords. It would not be in the nature of an explanation that is being given. This is the first time, my lords, we're coming across an FIR which is an explanation given and a story is then sought to be created as to how this entire incident happened. And, my lords, a defense is sought to be created even at this stage. Pleas of self-defense are there, my lords. Pleas of that it was unintentional, somebody getting hurt in the process. That is, my lords, planted at this stage. That's what I'm trying to comment. Now, my lords, at page 22, this is again another aspect which my state would probably have to explain, my lords. At page 22 is the conclusion of the FIR, my lords. On analysis, if my lords have it, my lords.
Yes.
On analysis of evidence, a prima facie case under 323, 506, 34 IPC is filed when established against the accused persons Rukhsana Yasmin, Sheikh Mohammed Aman, so-and-so, my lords, wife of so-and-so. Number 2 is Sheikh Mohammed Aman.
So it's not 324, it is 323.
323, my lords. I had submitted 323. My learned friend pointed out a summon which is under 324. The charge sheet is essentially under 323.
So charge has not been altered?
No,
Definitely.
not yet.
So it is simple.
It has to be under 323.
It is simple injury, is it?
My lords.
Even a simple injury case also you have to come for question between two brothers. It's sad.
My lords, my difficulty is, my lords, as I pointed out, had this matter been resolved at a different level, my lords, probably this kind of litigation would not have happened. Now there are two trials going on. There's this proceeding, my lords, people are out on bail.
The court feels sorry to, intervene in this kind of situation where like the parties are close relatives.
Related to each other.
And it is 323 is not even very grievous, it's not a very severe offense,
My lords.
So, we do not know. Anyway, it's not 324 also.
It's 323, my lords. Charges under 323. The dispute arose due to a family property which is situated at Bidar market, which led to a feud between the brothers and resulting in allegation and counter-allegation of injury, death threat, hurt. Therefore, I send them before the Honorable Court for facing trial under the aforesaid sections of law, and witnesses noted below will prove the case or may be summoned by fixing the date of hearing. Now, there's a note, my lords. However, during course of investigation, no evidence could be collected as against the above noted accused, which are charged against them under 326. There's no instrument of dangerous weapons and things like that. Hence, charge could not be framed under 326 against them due to insufficient evidence. Which again brings me back, my lords, to that issue, the query that fell for my lords, is that what was the time difference between the two FIRs?
That will be needed. That is the only thing, we have to take into consideration.
Because the prima facie reading of the FIR, my lords, before my lords would indicate that their FIR is subsequent in point of time. Because it says, my lords, in that paragraph, that when she said that stop the quarrel, they stopped the quarrel and they said they will file an FIR. So she's conscious of the fact, my lords, that an FIR is coming.
Just merely because there is some, difference between the lodging of the first one and the second one. There
May not be a consequence.
Expect both the parties to
go
to
together
at the same time and file FIR.
True, my lords. However, my lords, the FIR itself, which is before my lords, on the basis of which now I've been charged under 323-506, that would indicate, well, it's two things. That, yes, it is a counterblast. And well, I would have to, well, then continue with my submissions on the basis of whatever is there in the time difference, that first, well, and of course, if any statements under 164 have been recorded.
All right, this no problem.
You can seek a day's accommodation, well, if that is not inconvenient to me.
It's like accommodation cannot be for one day. It will have to be at least for 1 or 2 weeks. This is like they're very difficult.
I'm sure the board of this honorable court
got disturbed. Plus the 3 days in a week.
any day convenient. We'll continue from here.
Yes, Mr. Mansuri, what do you say?
Lord, my submission is very short.
No, we do not close your submission. Mr. Paul has not closed your submission. But then apparently you were raising some objection
My Lord,
against Mr. Paul.
my Lord.
So that is what you want to say, that he have argued the whole case. Now what should be the where he should confine? Mr. Paul, please take your seat. Just let's hear.
No, my Lord, my question is that under 482, why go into the facts?
No, if
Facts
there
are
is
not necessary here. Only two things are important, Your Lordship. Whether there is any cognizable offence or not. Whether it is the FIR is absurd or not. These are the Bhajanlal he mentioned. I think he has not gone through it.
Bhajanlal also
It's the
speaks
rarest of the rare case.
Wait. Bhajanlal also speaks about mala use.
My Lord,
There
my
are-
Lord,
just see,
my friend, I'll just show him. Let him read it.
No,
Rarest of the
you see,
rarest case.
Mr.
Please read it.
See, you have to address the court.
My Lord, he's making
not
fun
sitting
of
in the
me.
bar room, please.
He's laughing when I said it's mentioned here. Rarest of the rare case.
See,
He needs to go through, my Lord.
I'm sure,
you are to address the court.
My Lord.
You address the court.
My Lord, here it says that he mentioned about it, about Bhajanlal during his course of his argument. Yet he is saying this case is very clear. It says rarest of the rare case, High Court can costly under 482 FIR. It says. And he knows about it, perhaps. I'm not sure. Yet he's arguing the entire case, my Lord, on the merit. He's reading the charge sheet. He's reading the FIR. He's showing the medical cert. These are subject to evidence, my Lord. It has not been established, all those things. It has to be, it is yet to be established.
What are the conditions stipulated in Bhajanlal's case?
My Lord, Bhajanlal case, may I read?
How many situations are?
It's narrated here, my Lord.
Paragraph 101 or 102, 105. Oh, what is that? 102. Just see.
Which we have extracted and reproduced above, we give the following categories of cases by way of illustration wherein such powers could be exercised either to prevent abuse of process of any court or otherwise to secure ends of justice. Though it may not be possible to lay down any precise, clearly defined and sufficiently channelized and inflexible guidelines or rigid formulae, and to give an exhaustive list of myriad kinds of cases wherein such powers should be exercised. Now, number one, my Lord, where the allegation made in the first information report or the complaint, even if they are taken at their face value and accepted in their entirety, do not prima facie constitute any offence or make out a case against the accused.
This is one.
This is one, my Lord. Where the allegation in the first information report and other materials, if any, accompanying the FIR, do not disclose a cognizable offence, my Lord, justifying an investigation by the police officer. 506 is cognizable offence. Where the uncontroverted allegation made in FIR or complaint and the evidence collected in support of the same do not disclose the commission of any offence and make out a case against the accused. Here we have eyewitness, my Lord.
Just come to the point. Just go ahead.
Where the allegation in the FIR do not constitute cognizable offence, but constitute only a non-cognizable offence. No investigation is permitted by the police officer without an order of magistrate as contemplated under section 155(2) of Code. Where the allegation made in the FIR or complaint are so absurd and inherently improbable, on the basis of which no prudent person can ever reach a just conclusion that there is a sufficient ground for proceeding against the accused person. Now, my Lord, 6, where there is an express legal bar engrafted in any provision of the code or the concerned act under which a criminal proceeding is instituted, to institute and continuance of the proceeding, and or where there is a specific provision in the code or concerned act providing efficacious redress for the grievances of the aggrieved party. 7, my lord, this is the last one, where a criminal proceeding is manifestly attended with mala fide.
That is what
Yeah, exactly, my lord, this is mala fide. And where the proceeding is maliciously instituted with the ulterior motive for wreaking vengeance on the accused and with a view to spit him due to private and personal grudge. Now here, my lord.
That is what Mr. Paul's case is.
No, Mr. Paul's case is this. Then he should establish this by going through my documents.
That is what he was doing.
No, my lord.
And he cannot.
Medical certificates
cannot be established only by reading your FIR.
No, he's telling the story about his case.
Do not argue with the court, please.
My lord, my lord. Sorry, my lord.
Just to see whether there is mala fide or not,
my lord,
we have to look into the surrounding situation,
my lord,
which was in existence.
My lord.
So that is what. And to establish it, to some extent, we have to take into consideration the materials on record. No, may not be in the form of you say like conclusive evidence, but to see the prima facie, yes, this is the situation.
My lord.
That is what is our focus.
My lord.
So,
but on the other hand, my case also has to be seen.
We are not saying this. We are not saying that your case is not seen.
My lord.
Your objection was to Mr. Paul's taking this court into the facts.
Facts of the case.
Now, if mala fide is also a ground mentioned in Vajanlal's case,
my lord,
then definitely we have to see it.
My lord.
That is what. So there is no bar. As you initially started saying that like you see, like he has only thing is that he should confine itself whether there is a disclosure of cognizable offence or not.
My lord, the question here is basically what I understand. Mala fide intention, your lordship. It's very clear. It's fight. The FIR, both the FIR says there is a fight between the two. So one cannot say that one is right and one is wrong. In a fight, obviously there is a participation of the two, my lord. So how can we judge that one is right and one is wrong?
Yes. That is precisely why Mr. Paul was asked to give us the timing of his FIR. Because your FIR timing is mentioned.
My lord.
Yes. And then this court is also aware of the fact that this incident took place after 2:30 in the evening, maybe 3:30.
My lord.
So filing of your FIR just at around 8 is not very abnormal thing.
My lord.
Isn't it?
My lord.
You have to come over the shock
my lord,
of the incident, then you decide to come to.
There was a discussion in the family also, my lord.
There was hardly, if you take into consideration the time of the incident as projected in those things, there was hardly a gap of 5 hours between filing of FIR and the incident. Filing of FIR by you.
My lord.
So that is what we will see what he says. He is already, he's not in very comfortable job.
The seeking time.
Mr. Paul, when you will?
Any date convenient to my lords, it's a week from today. So any date.
This week we do not know whether the board will next week is very difficult. Next week?
It will be 2 weeks, my lord.
2 weeks. So we'll go to 2 weeks.
My lords may then permit me to file that charge sheet by way of an affidavit. I'll formally bring it on record.
Will it be required?
Just for the purpose of my lord.
That
Since
can
your
be produced
lordships
by the government, because they have.
No, anyway, let us see.
They've
You just
submitted
do
the
one
charge
thing.
sheet.
You do one thing, Mr. Paul.
Well.
You can carry the charge sheet with you. Copies, if we see if it is needed to be taken on record officially,
Well.
then we'll tell you, ask you to file it.
My lords.
And explore the possibility of things. Why 323 is to be? Yes, Mr.
I already expressed, my lord, before your coordinate bench also, my lord, I have expressed that I am ready.
Not at all appreciated. You should use your good office.
Exactly.
This is also a part of the job of lawyers.
Your lordship.
To see that there's no unnecessary.
I have conveyed several times to him that I'm
Your
ready.
social commitment is more than your professional.
My lord.
Your rather ambition. Okay, just hard landed counsel for the parties. At some length. Just wait for at least after 2 weeks.
That's
for further hearing.
Obliged. Obliged.
31.
Yes.
May I please? My lord, I had applied for the Zimma application from the lower court. The copy section could not find the file because it was registered as Zimma application and it was addressed to CJM. So there was a misplacement of the file. So they have asked for 1 week's time. I may be given 1 week's time.
So that is what you see. Do not
Yes,
just
ma'am.
say like you need some
Yes.
more time. Huh? First shift the blame to us and then you come to it.
That is also one way of seeking time.
Lordship, I have received.
Mr. Bora, this court appreciates fairness. That is one thing. This court will definitely appreciate free and direct submission. See, it is not that you should.
In 1 week, I think I'll get it. Yesterday only
Court
I
court may or may not give relief to you, but then it really appreciates.
Proceeding should be.
Lordship,
Yes.
Yes.
I had filed for the Zimanama. I have received the copy.
What is that?
I did.
It was given, it had fallen from my lords by order dated 23rd of May.
Wait, just a minute.
23rd of May, I was directed. It was stated here in the order, Miss Eshyam, learner GA, appearing for the state, shall also produce a copy of the related Zimanama bond,
Yes.
which
And-
was executed at the time of release.
Yes, but then we are now waiting for the Jima application, isn't it?
Yeah, it's come from that side.
No, that is, she has the Jima bond.
She has the bond.
I
This
have
is
the
the bond. This is the bond.
Jima bond. But
This is
then
the
we are
bond, not the
concerned with
application.
we need
I have
to-
applied for the application actually.
Because your contention was that the application
Contents
was
of the
filed by one
application is
person and it
important.
was,
Yes, ma'am.
Jima was granted to another.
Yes, my lord.
Okay. Yours one you produce on the next day? Yes.
Yes, Your Honor.
What is happening in this court?
Apologies,
I do not
Your Honor.
know. What is it? Do not, you are busy with yourself. You're not even bothered to even to reply to the query of the court.
Apologies, Your Honor.
Yes. The petition, Mr. P.K. Bora, come on, the petitioner appear in person. Praise for and granted further 2 weeks time.
Yes, ma'am.
Is it all right, Mr. Gautam?
Yes.
2 weeks time for placing a copy of the Jimma application number 22 of 2023 before this court in terms of earlier order dated 23/5/2025. You produce your thing, madam, on the next day.
Yes, Your Honor.
And please be considerate. When you are standing here, at least sitting there, okay, you talk between yourself. But then while you are standing, see, prime concern should be the court. List accordingly. Yes.
Obliged.
Obliged.
What is the problem you're referring to?